Before you listen to our lectures or utilize our materials, I first want to talk about why candidates pass and why candidates fail. Failing candidates lack the ability to convey legal knowledge within their analysis and rely solely on filling up their blue books with rule statements, thinking that is passing the essay and impressing the bar examiner and or the bar grader. That is far from the case. The bar exam is a test of analytical ability and reasoning ability. It is not a test of memorization. Anybody with a photographic memory, if that were the case, would be able to pass the bar exam. So you can go in there armed with all of the law, know the law as well as any of your fellow students who made law review, and still fail the bar exam because you do not understand the kind of writing that is necessary to pass. The kind of writing that's necessary to pass is the ability to convey legal knowledge within your analysis. So I tell my students who have been brainwashed into thinking mechanical IRAC is the way to go ahead, write an essay using your mechanical IRAC method. Then take a black marker to all of the rule statements. If the writing that remains behind does not contain legal knowledge, you are merely likely resummarizing and repeating the fact pattern in lieu of general legal knowledge, in lieu of the analysis the bar examiners are looking for. So merely identifying the facts is much different than actually using the facts. Candidates who pass know how to use the facts. Candidates who fail do not know how to use the facts, do not know how to write properly, whether it be an essay or a performance test. So again, write an essay with mechanical IRAC. Then cross out the rule statements, and if the writing that remains behind conveys no legal knowledge at all, but is merely a summary of the fact pattern, followed by the word thus, and a sentence that follows that particular word, that is not analytical writing. So you must understand the bar exam is not a test of legal knowledge, as odd as that might sound to you. Yes, of course, we do need to know the law to analyze properly. But knowing the law does not necessarily mean you possess the talent to convey legal knowledge within your analysis. Now, I know some of you will say, well, the State Bar website has some essays with rule statements. True, but the State Bar website also has essays that contain no rule statements at all and are merely written in a narrative fashion. And you can tell by these particular essays that didn't use rule statements that they knew how to convey legal knowledge within their analysis. So the key to passing the essay portion of the bar exam is definitely the ability to convey legal knowledge within your analysis. Now, I have seen many failing blue books through the years. I've been helping students pass the bar exam for over 20 years now, and they'll come into my office and say, I don't know why I failed. Here are my blue books. I will look over their blue books, and they'll even tell me, and I spotted all the issues. And oftentimes they have spotted all the issues, but there was no analysis underneath those issues. They merely wrote a rule statement, summarized the fact pattern, and then said something along the lines of, thus John is guilty of robbery. The poorest kind of writing goes as follows. John entered the store with the gun, pointed the gun at the cashier's head. The cashier turned over all of the money to John, and John fled the store. Thus, John is guilty of robbery and or commercial burglary. No, that is not how you write. Identifying facts is much different than using the facts, and you know you're using the facts if you are conveying legal knowledge within your analysis. Think of it like this. You've likely seen a lawyer argue either in the courtroom or oftentimes on TV, like such shows as Law and Order, etc. Lawyers do not stand before the judge and cite rule statements. Lawyers stand before the judge and start analyzing and conveying legal knowledge according to the element that they are trying to prove. So what you need to understand is you are being graded on your ability to convey legal knowledge within your analysis. And the same holds true for the performance test. You can't merely restate the fact pattern and think you're going to pass a performance test. What most people do wrong on performance tests is they simply cite the holding of the case. They do not cite the facts of the case, and if you do not cite the facts of the case, you cannot compare the facts in your file to the facts of the case law in the library. So remember, skillful candidates pass, unskillful candidates do not pass. So you must learn the ability to convey legal knowledge within your analysis, so that if we take a black marker to your rule statements, if you choose to write in the mechanical IRAC fashion, the writing underneath the rule statement must convey legal knowledge. That is what gets you the top grades. And by the bottom of page 1, the bar grader can see whether you're conveying legal knowledge within your analysis or if you're merely listing and regurgitating and summarizing the fact pattern. That writing leads to a complete, absolute failing grade. Like I said earlier, I will have students come into my office, show me their bar books from the last bar they took, and there is no analysis. Even though, yes, they spotted all of the issues. But the California bar exam, what separates it from other states is that it's not necessarily a hard exam. It is graded hard, meaning you basically have to write an essay that's equivalent to whatever your law review peers wrote when they were in law school. So the standards are high on the California bar exam. It is not merely an issue spotting exam. Many states, if you spot the issues, you in essence automatically pass because there is no emphasis on legal analysis in certain jurisdictions. So remember, California, it's not the hardest exam in the country. It's just graded the hardest. If you really think about it, the essays are not difficult. They're very short. The PTs are now going to be an hour and a half. Not very difficult, very short. And just remember, you have to practice the ability to convey legal knowledge within your analysis. And I will say it one more time to bring this point home to you. Write an essay with mechanical IRAC. Take a black marker to all of the rule statements. If the writing that remains behind is merely a summary and regurgitation of the fact pattern, you will certainly fail that particular essay. So you need to learn the writing style that the bar examiners will basically give the benefit of the doubt at the bottom of page 1. Now, I know you've heard the bar graders grade essays in 2 to 3 minutes, and that's not a myth, that's the truth. I can grade an essay in 45 seconds and know whether the person has the ability to convey legal knowledge within their analysis, which is what the bar examiners are looking for. They're not merely looking for people that can identify facts and regurgitate the facts and summarize the facts in their blue book and then follow it with their thus, which is in essence their conclusion statement. Unless you've provided legal knowledge within your analysis, you have not earned the right to use the word thus. I remember one student a few years back, she wrote a PR essay, spotted every issue, but the essay contained nothing but rule statements and a summary of the fact pattern, and that is why she got a 55, even though she spotted all of the issues. So keep in mind the California bar exam, you're being graded on your issue spotting ability as well as your analytical ability. Most other jurisdictions are merely based on whether or not you can spot the issue. Now, another thing some of you may or may not have been told about a California bar exam essay, it's basically a client walking into your office and telling you a story. And the bar examiners want to know if you will be able to convey the proper legal knowledge and solve the problem to the client that comes into the office and tells you their story. That's really what a bar exam essay is. That's really what's being tested. It's a client walking into your office, telling you their problem, and the bar examiners want to know, can you spot the issues and can you convey legal knowledge within your analysis when explaining the situation to them? So in sum, until you learn how to convey legal knowledge within your analysis, you will continue to fail the bar exam, especially the essay portion of the bar exam. There's no ifs, ands, or buts about it. If you're merely regurgitating the fact pattern, thinking you're analyzing, that will result in a failing essay. Now, point out the good part about being able to identify the proper facts. Being able to identify the proper facts is good. It means that you know what facts matter and what facts are significant. But if you're merely listing them and resummarizing them and regurgitating them, you are not conveying the ability to convey legal knowledge within your analysis. Until you learn that ability, the bar exam will be difficult. And on that note, if you've taken the bar exam 3, 4, 5, 6, 7 times, I helped a gentleman pass on his 20th try. And his writing style was the kind of bad writing style that I've described in this little blurb to you. So he came to me after bar 18, failed it 18 times. I looked at his blue book and I said, Frank, there's no analysis. You're spotting the issues and merely regurgitating the fact pattern. I worked with him on bar 19. He scored 14, 20 something. I knew the next time I worked with him, as we were getting close to the bar exam, he had finally grasped the ability to convey legal knowledge within his analysis, and he passed on try 20. He still to this day wishes he would have met me right out of law school. Now, very few courses will tell you this. You can write an essay and regurgitate the fact pattern, and I'm not going to name any of the big courses or any of the smaller courses, but I've seen 70s and 75s given to such essays, and that creates a false sense of hope in the student, thinking that they are indeed writing the right way. But it's the opposite. They're actually writing the wrong way. So remember, if you're involved in a big course, one of the monopoly quote-unquote type courses, they do not have graders that are going to spend 10 to 15 minutes on your bar exam essay, call you up on the phone, and explain to you how to convey legal knowledge within your analysis. Most of the big courses have ABA students, and most ABA students naturally know how to convey legal knowledge within their analysis. So, if you learn to convey legal knowledge within your analysis, you will become a skillful enough candidate to pass. So what I want you to take away from this little blurb is you are being graded on the way you write underneath your rule statements. You are not being graded because your rule statements are perfect hornbook statements. You're being graded on the way you write underneath your rule statement. And that should make sense to you because, again, the bar is not a test of memorization. Like I said earlier, anybody with a photographic memory would be able to pass the bar exam. There's plenty of people out there that can memorize entire phone books. But if that person memorized all of the law outlines at his disposal, he would not be able to go in and pass the bar exam because he will lack the ability to convey legal knowledge within his analysis. And our essays that we provide you demonstrate that to a T. You can cross out our rule statements, though we don't write with the rule statements. We don't provide model answers with rule statements. So, learning how to convey legal knowledge within your analysis is hard for some people to learn, but we do have exercises that we put you through that will change your writing style within 7 to 10 days and put you on the road to passing the bar.